Your Honor, this case, I've said it before and I will reiterate, is deeply, deeply tragic. And that cannot be overstated. But tragedy can't substitute for probable cause for murder charges. The motion asks the court to dismiss counts 1 through 4 and 1 through 4 only, the murder counts, because the preliminary hearing on those counts and those counts alone, according to this motion, were fundamentally compromised. The prosecution withheld the very evidence that would have allowed the defense to show at the preliminary hearing that speeding on that particular stretch of PCH, while it may be dangerous, certainly even reckless, was not historically or objectively an act whose natural and probable consequence involved a high degree of the probability of death. It's not a motion about whether or not the collision was devastating. Everybody in this courtroom knows that it was. It's not a motion about whether speeding is inherently dangerous. It is. We can all agree on that. But implied malice murder requires more than just tragedy and more than just danger. To repeat that incredibly important standard, it requires proof that the natural and probable consequences of that act and that act alone, as one court put it, is nearly certain to cause death. That's the line between gross vehicular manslaughter and murder. And that's the evidence that the prosecution failed to provide to the defense. And that's the evidence that goes directly to that line. The procedural vehicle that we have before us, as the court said in the Stanton motion, common law motion to dismiss, it matters, and it involves constitutional issues. The motion is brought as both a common law statutory motion to dismiss and, as it's to the extent that it's applicable, a renewed 995 motion. California law recognizes this very remedy. It recognizes it for a reason, because where the denial of material evidence prevents the defense from exercising a substantial right on behalf of Mr. Bohm, this is the remedy. This is the court. The preliminary hearing, as the court well knows, is not simply a formality. It exists to weed out unsupported and grave charges before the defendant's forced to stand trial on those charges. The defense has the right to confront witnesses, to cross-examine witnesses, to do that meaningfully, to present evidence in its own defense, to impeach prosecution evidence, and to negate elements of the charges. And when favorable evidence is withheld from the preliminary hearing, the harm is not cured by saying, well, it's okay, they've got it now, they can use it before trial. The harm is that the magistrate's probable cause determination, Judge Edberg, 3 floors down, his probable cause determination was made on an incomplete record, and Mr. Bohm's statutory and his constitutional rights for the preliminary hearing, at the preliminary hearing, they were denied when they mattered most. At the preliminary hearing, the people relied very heavily, almost entirely, on Mr. Calandra to portray Mr. Bohm in a very particularized way, being irresponsible and distracted immediately before the collision. Mr. Calandra testified that Mr. Bohm was texting on his phone and that phone was between his legs, under the steering wheel, and his thumbs were moving on the keyboard. The phone data later produced and analyzed by a forensic expert contradicted that testimony completely. That phone was locked from 8:15 and 59 seconds p.m. until 8:30 and 6 seconds p.m. There was no user interaction with that device during the entire 15 minutes prior to the accident. The expert established unquestionably that Mr. Calandra's testimony was false. When he suggested that he personally saw Mr. Bohm with both thumbs when he suggested that he personally saw Mr. Bohm with both of his thumbs ripping away at the keyboard, texting away, that was in fact a lie. He could not have seen that because there was no texting, there was no interaction. And it makes one wonder why Mr. Calandra thought it was prudent to lie under oath or to lie to the authorities about that. We'll save that, obviously, we'll save that argument for another day. They relied on his friend's accident to argue that because his friends died in a car accident because of speeding, Mr. Bohm would know that speeding results in fatalities. Except at the moment the people made that argument, They were also in possession of a police report that indicated that the primary cause of his friend's tragic death was DUI. It wasn't speeding. The primary cause was because his friend was driving at a .12 blood alcohol content. They had that report in their possession and was never provided to the defense during the preliminary hearing or before the preliminary hearing. Here are some of the facts related to the exculpatory information that we've laid out in myriad exhibits before the court. After the preliminary hearing was over, after it was settled, after the holding order, the defense obtained what the prosecution did not produce: collision data, Caltrans reports, sheriff's reports, Lost Hills Station reports, CHP Malibu task force reports, City of Malibu materials, Captain C2, as the court now knows, was the captain at Lost Hills Station, her deposition testimony, her presentation materials to the city, Senate Bill 1297 materials, the Stantec safety study, and expert analysis. That's just a smattering of the things that we recovered, all obtained by us, and all within the prosecution's custody and control before the preliminary hearing. And the picture those data paint is materially different than the picture that was presented at the preliminary hearing. The evidence that we presented, that we have now uncovered, shows that there is chronic speeding on PCH. It shows that there are recurring collisions, one after another after another. It shows governmental recognition of those speeding issues and those recurrent collisions, and government recognition of a serious traffic safety problem in Malibu and on that particular stretch. But importantly, and most notably, that data also shows that fatal collisions are rare. Not just rare, Judge, extremely rare, relative to the volume of speeding, the volume of citation, the volume of collisions. On that precise 0.8 mile stretch, this is where I'll start supporting my argument with the PowerPoint to give the court some visuals. On that precise 0.8 mile stretch between Carbon Canyon Road and Las Flores Canyon, in the 10 years before this case, SWITRS, which as the court knows is called the Statewide Integrated Traffic Records System, SWITRS, identified 129 reported collisions. The actual case listing establishes this, and the government's own report establishes this, and it's run from the government's own database, not a database that we created, a database they created and they had. Then Caltrans produced approximately 50 additional collision reports that were not included in the SWITRS data. So we have 129 from SWITRS and an additional 50 from Caltrans. And that was also obtained by subpoena by the defense after the preliminary hearing, and it was never produced in discovery. Together, that's approximately 179 collisions on the same stretch of road over the course of 10 years. The only fatal collision in that combined data set is this case. The only fatal collision in this case. And that speaks directly to the objective element, Judge. The prosecution's entire theory of the preliminary hearing depended on treating excessive speed on this stretch of road as conduct whose natural and probable consequences involved a high degree of probability of death. That was their theory. They can't run from it. They can't hide from it. They said it, they theorized it, and that's what they presented to Judge Edinburgh. But the undisclosed government history, the 10 years worth of government data, shows exactly the opposite. Repeated speeding, repeated collisions, and not a single other fatal collision in 10 years on that stretch of road. Not one. And we didn't have that data to make that point in front of Judge Edinburgh at the preliminary hearing. Murder requires proof of a very particularized mental state. They argued it. There was a counter argument that we couldn't make because they didn't provide the data and the information to us. And that is, in the weeks after October 17th, this tragedy, radar on this highway documented speeds of 107, 109, even 112 miles per hour. Those Lost Hills Station reports with them memorialized in photographs, which the court has in front of it. And that's just a sample that is not exhaustive. The sheriff's monthly report for November 2023, that same 30-day period right after this incident, it shows that the road conditions are the same, obviously. They haven't changed. There was no marked difference. And that report indicates 16 collisions in Malibu, citywide. Unsafe excessive speed was the #1 primary collision factor. And it records 0 fatal collisions and 0 deaths. And again, more data that indicates chronic and extreme speed persisted after the tragedy, but the high degree of probability of death did not persist because it doesn't exist. That high degree of probability of death is not borne out by the data and the facts. I wanted the court to see the government's own chart for 2023. The reason 2023 is important is because that happens to be the Malibu corridor's worst year on record in the last decade or so for the data that we were able to recover. That's the worst year, 2023. They had this information. The government had it in their possession the entire time. They had it before they argued to the magistrate that speed constitutes a high probability of death. They had this information. 223 reported collisions on PCH in Malibu for that year, 2023. 127 included property damage only. 93 included some sort of injury to human beings. 3 fatal collisions. And Your Honor, the defense does not minimize a single one of these fatalities. That's not why we're here. We're not minimizing any of those. They're all devastating. They're all tragic. But the government's own chart, which you can see in front of you, shows that fatal collisions are the smallest percentage on the chart. That's their chart. I didn't create this. I just got it. 1.35%, even in the worst year. The data was also compiled by the government from 2013 to 2023. That's a full 10-year span from Malibu at large. Not just, we talked about a 10-year period on that stretch of road. Now we're expanding this to a 10-year period in Malibu at large. 3,345 collisions, 49 fatality collisions, thousands upon thousands upon thousands of tickets for excessive and unsafe speed. And again, unsafe excessive speed was the largest primary collision factor. That's why people were wrecking on PCH, because of speed. Massive volume of traffic, massive volume of enforcement, chronic speeding, and fatality collisions remained under 1.5%, as you can see on your screen. That's not the high probability outcome that the people argued at the preliminary hearing. They had the data, we didn't. And that brings us to the preliminary hearing. I want to talk about that specifically for a second and what was argued there. And this record we've been talking about answers directly the people's own theory of the case, the theory that they cannot run from. At the preliminary hearing, the prosecution argued, quote, there has to be a number. This court saw that when it reviewed the preliminary hearing transcript. There has to be a number. Mr. Bartos argued there has to be a speed at which driving simply becomes murder. A speed at which there's automatically a high degree of probability of death. Not danger, not carelessness, not injury, but where a particular speed equals death. That's what their argument was. There has to be a number. But that is not the law in California, Your Honor. A prosecutor can't simply convert speed into malice by announcing some arbitrary number, especially when the data that was withheld from the defense is the exact evidence Mr. Bohm was entitled to in order to rebut that theory with the actual facts. If we would have had that data, Mr. Bohm had that data, which was in the government's possession and compiled for this very reason, to have discussions about these probabilities. The court very well might have asked, and this court might ask, okay, well, in the past 10 years, how many citations were there, Mr. Jackson? You said there's thousands. Over 42,000. That's how many citations. Okay, but how many of those were for speeding over 100 miles an hour in the area? We don't have to guess. Captain C2 told us speeding over 100 miles an hour is commonplace every single weekend, week in and week out. Okay, right. On this stretch of road, let's narrow it to this stretch of road. How many resulted in collisions? We know the number, 179. And how many of those other collisions resulted in a fatality? 0. Not one.
How many involved in collision with a pedestrian?
That's not in the data set that we have.
Yes, it is. I'll get to that.
They do talk about pedestrian versus vehicle-vehicle collisions, but I don't believe that they've narrowed down just which fatalities were pedestrians and which were vehicle-to-vehicle. There's some that include both. But still in the data set, out of 10 years worth of data on that stretch of road, which is what the government argued, how many resulted in fatalities? None. Not one, other than this one. That would have been good for the defense to know. As the court can imagine, that would have been data that we would have wanted to present at the preliminary hearing. That would have been good for the magistrate to know because it directly impeaches the people's own theory. We're not saying that a pedestrian collision isn't fatal. It can be. We're not saying that car-on-car collisions can't be fatal. They can be. What we're saying is there a high degree of probability of death just because you hit a particular speed? And the answer resounding, based on the data, is absolutely not. It's directly exculpatory of the charges of murder. And to close this loop, I want to briefly discuss local law enforcement and the government's response to all of this data. It illustrates that the people were in possession of this data long before the preliminary hearing. They had access to it had they just given it over to the defense.
The framework of what we're talking about, and foundation of what is required. It appears that the defense initially argued that there were 2 violations, and now they brought up a third of the people not providing evidence, which is favorable to them. It appears it's the citations, the statistical information, the sheriff's reports relating to collisions on PCH, none of which involve the defendant. That's that first bucket. The second being the phone that belonged to the defendant that was in the police custody. And then the third, and I'll just address this quickly because I think it is can be easily dealt with, is the report from the Ventura County Sheriff's Office that lists the DUI as being the primary factor for Mr. Ocean's collision and death, and it also indicates speed. Now, that third one specifically goes to the defendant's subjective knowledge. He knew because he was asked the question, are you familiar with the phrase speed kills? And he brought up this information. His understanding of the dangerous to human life that speeding represents is what's important for the subjective. The fact that there were other factors involved, and he even says, I don't know the full story. That's in the interview that he gives with the deputies. But his understanding is what is important in that case, which was that speed was a factor in the deaths of his friends, and indeed it was. So I don't see how the other information can go into what to change his knowledge post facto. The other thing that we have to look at is what the court is basing the understanding that these are, as the defense is alleging, that these are favorable to the defense. And so much of that is born on the foundation that speed alone, number one, is the people's theory, and number two is the standard by which the courts look at for implied amounts. Neither one of those things are true. It hasn't been true when the case occurred, when it was filed, wasn't true at the time of the preliminary hearing, it's not true now, and it won't be at trial. So the court understands procedurally the phone was in the possession of people. The sheriff's office was making attempts to crack into the phone because we did not have the password. So we had a physical phone, but what we're really talking about here is the encrypted data that was on it. The people were able to get a partial download of that phone, not a complete download, because we didn't have the password. We informed the defense that it was not a complete download. We provided what we were able to get off of it to the defense prior to the preliminary hearing. They had that data. It showed that there were no texts, there were no calls, there were no interactions with apps during the time period immediately before the collision. So that was known to the defense, and that was used as part of their attempt at impeachment of Victor Calandra. Because Victor Calandra, before and then at preliminary hearing, said that the defendant was texting. That was his testimony that came out. And I inquired, how do you know? You don't know that he's...
Makes the tree go outside.
questioning whether or not he actually could, from the position that he was in, tell that the defendant was actually texting on his phone. And he was cross-examined on that by the defense. And the use of the phone data that the defense says that we never should have engaged in was when the defense requested a stipulation to the fact that there were no texts or calls that went through at that time, which, based on the evidence that we had, the people were more than willing to do because it was the state of the evidence, and it's still the state of the evidence. What they're saying is that they were able to, by getting the phone and having the unlock code, which occurred after the preliminary hearing, and we had a hearing here in court about it, and that's when the court ordered it to be done, that somehow that extra information now turns Victor Calandra into a liar that undermines the entirety of the people's case.
In my view, the non-disclosed evidence does not foreclose the possibility of a high degree of probability of death and may even support a finding that the defendant's acts are acts, the natural and probable consequences of which are dangerous to human life, in that they involve a high degree of probability that they would result in death. Bohm was not denied a substantial right to the preliminary hearing because the people had no constitutional obligation to disclose the evidence at issue. This alone mandates or requires a denial of this motion, and the court need not even reach the question of whether the evidence at issue would affect the magistrate's or would have affected the magistrate's determination of probable cause, such as the defendant's entitled to dismissal. But even assuming, arguendo, that the evidence at issue was required to be disclosed to the defendant pursuant to Brady or any other discovery statute, the addition of the non-disclosed evidence to the evidence heard by the magistrate would not have affected the probable cause determination in this case. The motion is respectfully denied.
The deadly Malibu crash that killed 4 Pepperdine students back in 2023.
Packed courtroom today in Van Nuys. This is where a judge denied a motion to throw out murder charges related to the crash that killed 4 Pepperdine students in 2023.
A judge today now saying the man behind the wheel will stand trial on all charges.
Alan Jackson arguing the deadly crash doesn't meet the standard for murder charges.
Is there a high degree of probability of death just because you hit a particular speed? And the answer, resoundingly, based on the data, is absolutely not.
Bohm's previous attorney had argued that Bohm was trying to get away from a road rage driver at the time of the crash.
Bohm, who investigators say was driving more than 100 miles per hour in a 45-mile-per-hour zone, is now charged with 4 counts of murder and 4 counts of vehicular manslaughter with gross negligence.
The court's not being asked to dismiss this entire case. That's not what we're here doing. This motion targets counts 1 through 4, only the murder counts.
Defense attorney Alan Jackson said in order for Bohm to be charged with murder, the prosecution must prove that the act alone was nearly certain to cause death. Jackson says he collected data not provided by the prosecution that shows fatal crashes in that area are extremely rare.
Together, that's approximately 179 collisions on the same stretch of road over the course of 10 years. The only fatal collision in that combined data set is this case.
Jackson also said that the prosecution previously withheld data from Fraser Bohm's phone, information that may have called into question statements made by witnesses. But the judge denied the defense's motion to drop the murder charges, saying the prosecution provided all the evidence immediately available to them, adding a number of factors led to the decision to charge Bohm with murder.
Including some evidence that the defendant was distracted while driving. Indicated there was evidence indicating that he was swerving and veering across lanes and those sorts of things. He also was traveling 99 miles an hour when the airbags deployed. The motion is respectfully denied.
Speed alone is not what the people are arguing. Dangerous driving, not just speed.
That trial set for September 8th.